Eron Kiiza, a lawyer for opposition leader Colonel Dr. Kiiza Besigye, was sentenced yesterday to 9 months in Chitalia prison for contempt of court following a confrontation with a court orderly at the General Court Martial. The ruling sent shockwaves through the legal community and ignited an intense debate on social media, with many expressing disbelief and concerns for the integrity of the judicial system. In response, the Uganda Law Society swiftly issued a statement condemning the actions taken against Kiiza. The Law Society's stance is shared by many colleagues in the legal profession and human rights advocacy groups who have vowed to challenge the sentence through legal channels. While the specific approach has not been revealed, an appeal is already underway.
We are concerned about the unlawful arrest, conviction and detention of Mr. Eron Kiiza. He was yesterday, in the course of his work as a defense lawyer for Dr. Kiiza Besigye, convicted for contempt of court by the General Court Martial. He was denied his constitutional rights of a fair hearing and he was condemned unheard. We will be taking various legal steps to challenge injustice and restore him to freedom.
Lawyers argue that while contempt of court is a legitimate charge, the core principle of due process must always be upheld. They assert that Kiiza was not only accorded a fair opportunity to present his case, a right that is enshrined in the Constitution.
Contempt of court is one of those cases that can be exempted by the Constitution, that any court can charge you without expressing the ingredients. However, the Constitution doesn't preclude or doesn't exempt anyone from being condemned unheard. So there's no exception that if you're being charged with contempt of court, you don't deserve a hearing. We all know the manner in which he was arrested. We saw that he was roughed up, he was assaulted on arrest, and we are saying that irrespective of what he was being charged with, his constitutional non-derogable rights were violated, and those are what we are seeking to challenge, and we think that the entire processes violated that.
Additionally, legal experts point out that the ruling did not specify the legal provisions under which Kiiza was convicted. They argue that under the UPDF Act, sentences for contempt should not exceed 30 days, making the 9-month sentence particularly troubling.
If you look at the ruling of the court, it didn't even specify under which provision he was convicted or sentenced, because ideally the sentence should not have gone beyond 30 days from the provisions that we know of the UPDF Act. But since the ruling didn't give us a benefit of knowing under what provisions was sentenced, we shall test all that before court.
Another point of contention is the ongoing delay by the Supreme Court in delivering a verdict on the Attorney General's appeal regarding the Michael Kabaziguruka's case. The Constitutional Court had previously ruled that civilians should not be tried in military courts, raising questions about the jurisdiction of such courts and adding further complexity to Kiiza's case.
The courts of judicature, and especially the Constitutional Court, has already held that the military courts are not parts of the courts of judicature. Rather, they are specialized courts that try military men for service-related offenses. And the court held that civilians are not supposed to be subjected to those courts. And you see, the point we are making here is that the Supreme Court has delayed its appeal to consider the appeal that was made by the Attorney General on that point. And as a result of that, the military courts have continued to try civilians as if they are part of the military. So that's why we urge the Supreme Court to deliver the ruling on the appeal, because justice delayed is justice denied.
David Ijo, NTV Tonight.